dream I know deep up my feelings for you.
The Federal High Court sitting in Kano State has set aside the restatement of Mohammed Sanusi II as the 16th Emir of Kano. Moving on after this, we have the Kano government reinterprets court ruling saying that Mohammed Sanusi remains the Emir of Kano State and they have ordered the demolition of Bairo's Palace. But guys, before we comment fully, welcome back to my wonderful channel Reality Latest Gist, as we bring you back-to-back updates and information as it hot. So if today is your first time to join this wonderful channel, kindly subscribe, like, comment, share, and also turn the notification bell to get notified whenever we drop our video, because I'm sure you don't want to miss out the wonderful and trending news happening on social media. To all our amazing subscribers, thank you so much for joining us on today's news. So guys, let's proceed. The Federal High Court sitting in Kano and presided over by Justice A.M. Liman has set aside the restatement of Mohammed Sanusi II as the 16th Emir of Kano. The court refused to nullify the Kano Emirate, but they set aside steps by the state government in pursuance of the law. So the judge, Justice Liman, however, while delivering his ruling, ordered that status quo be maintained by all parties. So according to him, he said he hereby ordered that every step taken by the defendant in pursuant to Kano State Emirate Council law are hereby annulled and set aside, that this order does not affect the validity of the law, which is the subject matter, and he refused to pray by the applicant to nullify the law. So he has ordered that status quo should be maintained, because the judge bases his ruling on the ground that the government is aware of the court's order to maintain status, but they went ahead to take further steps and actions. So he is so convinced that the respondents are aware of the order dated May 23 to maintain status quo pending the hearing and determination of the case, and he thought it is a very serious matter for anyone to flaunt the order of the court and go scot-free with it, because the catastrophic situation could have been averted if the respondent followed due process by complying with the court order, which would still have allowed them to carry out their assignments. You guys can record that earlier that the counsel to the applicant, MS Waziri, urged the court to nullify the Kano Emirate Council Law 2024. Also, Justice Liman, while delivering ruling on the stay of proceeding, granted the application for stay of proceeding on jurisdiction of the court to entertain the matter. My people, before all this garga started, earlier, the counsel to Kano State House of Assembly and Speaker Eyitayo told the court that he has filed a notice of appeal at the Court of Appeal and motion on stay of proceeding. Eyitayo also applied to be rescued from the matter, asking for an adjournment to enable his client to find another lawyer, and pending hearing and determination of his application at the Court of Appeal on jurisdiction. So, counsel to Attorney General of Kano State and the state government, Mr. Wakil, aligned himself with the position of Eyitayo. Also, counsel to the Commission of Police, Kano, and Inspector General of Police, Mr. Sunday Ekwe, told the court that the duty of the police was to maintain peace in the state, which is why they did not file any responses on jurisdiction issue. And they can record that the applicants, Saki Dawaki of the Kano Emirate, Aminu Babu Danguni, had approached the court seeking his fundamental human rights, and that the court should restrain the respondent from enforcing, implementing, and operationalizing the reappeal law. So, however, the respondent in the suit are Kano State government as first respondent, Kano State House of Assembly as the second, Speaker of Kano State House of Assembly as the third, then Attorney General of the Kano State as the fourth, Kano Commission Police as the fifth, Inspector General of Police as the sixth, and NSCDS and DSS as seventh and eighth respondents, respectively, by people. Emir Sanusi dethroned twice, which means Emir Ado Bayero would become the fifth and seventh Emir if this judgment stands. Now, my question is, what law did they now use to dethrone the Emir Sanusi earlier? Was that illegal? Waiting concern court with loyalty. Whoever the state government recognizes is the Emir. Now, waiting me think, though politicizing the ancestral throne has turned the Emirate to a joke, not as their own country, as we see above, because waiting they happen for North different from wetin dey happen for Nigeria. So my people, I go like know wetin I think about this matter in the comment section. I would love to hear from you. Moving on to the next one. The Kano State government has directed the State Commissioner of Police to remove the 50th Emir of Kano, Aminu Ado Bayero, from the Nasarawa Milling Palace. The state government claimed that Thursday's judgment by Federal High Court was in their own favor, affirming that the state government decision to retain Emir Lamido Sanusi. You guys can recall that there was a report that the court nullified the Kano Emirate Council Law 2024 that scrapped 4 of the 5 Emirate Council of the states last month, and they removed all the 5 emirs, including Aminu Ado Bayero of Kano. So the judge, Abdullahi Lima, ruled that the appointment of Mr. Sanusi as Kano Emir was null and void because the government failed to obey the court order restraining it from taking further action on the new Emirate Council law. So the judge described Governor Yusuf's speech during the presentation of the reappointment letter to Mr. Sanusi as a road to anarchy, saying that if a court order cannot be respected despite evidence of service, then the government was heading to chaos. So he voided all the actions taken by the governor after the court order, including the signing of the new emirate law and subsequent appointment of Mr. Sanusi as emir, and order all parties in the case to maintain the status quo. But in a swift response, the State Attorney General and Commissioner for Justice, Haruna Didari, in a press conference, said that the court ruling was in their favor and Mr. Sanusi remained the emir. He said that government has already concluded arrangements for the general reconstruction and renovation of the properties, including the demolition and reconstruction of the dilapidated wall fence of the Nasarawa Palace with immediate effect. So following this court ruling, Kano State government has directed the Commissioner of Police to remove the disposed emir of the 8th metropolitan local government from the government property. Hey, my people will be so loud. As the government has already concluded arrangements for the general reconstruction and renovation of the property, including the demolition and reconstruction of the dilapidated wall fence with immediate effect. So by the ruling of the courts, it has unequivocally reaffirmed the validity of the law passed by Kano State House of Assembly and asserted to by His Excellency the Executive Governor of Kano State on Thursday, 23rd May 2024. My people, this part of the judgment is very fundamental to the entire matter. Further implication of the ruling is that all action done by the government before the emergency of the interim order of the Honorable Court are equally validated. So this means that the abolition of the 5 emirates created in 2019 is validated, and the deposition of the 5 emirs is also sustained by the Federal High Court. So by implication, this means that Mohammed Sanusi too remains the emir of Kano. The judgment also granted their application for the stay of proceeding until the Court of Appeal deals with the appeal before it on jurisdiction. So happily, the signing of the law and the restatement of His Highness Emir Mohammed Sanusi II were done on 23rd May 2024 before the emergency of the interim order, which was served on them on Monday, 27th May 2024. So the state government are claiming that Emir of Sanusi remains the emir of Kano State. My people don't be small matter. Now so many people don't on the talk say Mohammed Sanusi emergency as emir was politically motivated, that he was not the rightful heir of the throne. My people don't be small matter. That the judicial rascality was at its peak because it has been long they settled chieftaincy matter in Federal High Court because chieftaincy matter are not within the jurisdiction of the Federal High Court. So they hope someone files a petition against this judge so that they will use person as an scapegoat. My people don't be small matter. My people, that's some people call the say waiting concern court with royal wahala that the state government should have the final say on the issue. But guys, if una think say na so it's supposed to be, make I know what you think about this matter in the comment section. Let's keep it lively in our comment section. Once again, thank you all so much for staying to us. We really do appreciate. On this note, we have come to the end of today's segment.